I call the Lake Mills Plan Commission meeting of November 24, 2015 to order. We'll proceed now with a roll call.
Mr. Foster?
Here.
Ms. Lazaris?
Here.
Mr. Magnuson?
Here.
Mr. Schwark?
Here.
Mr. Pearson?
Here.
And Mr. Holman previously informed me he would not be available this evening.
Okay. All right, very well. All right. Item number 3, correction and/or approval of the minutes, October 27, 2015.
I move to approve as published.
Second.
It's been moved and seconded. Any comments? In that case, I'll proceed with the roll call vote.
Ms. Lazaris?
Aye.
Mr. Magnuson?
Aye.
Mr. Schwark?
Sustain.
Mr. Pearson?
Aye. Aye.
Mr. Foster?
Aye.
Motion passed 4-0.
All right. Item number 4, questions and public comment. The public may address the commission at this time regarding items on the agenda unless the item is the subject of a public hearing. If your comments do pertain to a public hearing, please hold your comments until the hearing. Public comment may also be made at this time on items not on the agenda if you have registered with the city clerk before the meeting. The state's open meeting law discourages action by the council on items not listed on the agenda. Please limit your comments to 3 minutes and state your name and address when starting your comments and fill out the sign-in sheet at the podium. So we do have 2 public hearings this evening. The first is the conditional use request by John Laundrie for a restaurant drive-through at West 7659 County Road V, parcel 018 0713 1223 003. It is on Tyrone Road. The second public hearing is on a tax increment financing amendment to the territory and project plan for tax increment financing district number 4, which involves this parcel. So those are the 2 public hearings this evening. Are there any comments or questions that do not concern these public hearing items at this time? Okay. Does anyone wish to speak under questions and public comment? Yes. Would you wish to speak for the public hearing? I do. Okay, aye. Then we'll call out the public hearing at that time. All right. All right. Hearing nothing further under questions and public comment, that is closed, and we move on to item number 5, public hearing. Conditional use request, John Laundrie Restaurant Drive-Through, West 7659 County Road V, parcel 018 0713 1223 003. Under the condition this property first be annexed into the city of Lake Mills. Okay. Before we open the public hearing, I'll go over the Plan Commission motion, and then I will call on staff to provide some background on the conditional use request and present it, and then we will open the public hearing for comment. The Plan Commission motion before us is motion 15-11-1. Recommendation to City Council for conditional use permit, drive-through for a restaurant, West 7659 County Highway V. Motion 15-11-1 sets forth zoning authority in the city, that the city has specific requirements for conditional uses. It sets forth the conditional use request by John Laundrie for a drive-through at a permitted restaurant use. Sets forth the review by city staff and tonight's public hearing. Motion 15-11-1 provides for a Plan Commission recommendation to the City Council to approve the conditional use with the following conditions. 1, annexation of the Culver's parcels to the city with planned business zoning approved. 2, that the site plan meet all the requirements noted in the planner's memo. And 3, that the Plan Commission makes the following findings. First, the proposed conditional use of a drive-through in a specific location is in harmony with the purposes, goals, objectives, policies, and standards of the city's comprehensive plan and any other plan or program adopted by the city. 2, the proposed conditional use of a drive-through in its present location and as depicted on the site plan does not result in a substantial or undue adverse impact on adjacent property, the character of the neighborhood, environmental factors, traffic factors, parking, public improvements, public property or rights of way, or other matters affecting the public health, safety, or general welfare. 3, the proposed drive-through conditional use maintains the desired consistency of land uses, land use intensities, and land use impacts as related to the environs of the property. 4, the proposed drive-through conditional use is located in an area that will be adequately served by and will not impose an undue burden on any of the improvements, facilities, utilities, or services provided by public agencies serving the property. 5, the potential public benefits of the proposed drive-through conditional use outweigh any and all potential adverse impacts of the proposed conditional use as identified in the items 1 through 4 that I just cited. After taking into consideration any proposal by the petitioner and any requirements recommended by the petitioner to alleviate any such impacts. So that is the motion, and now I'd like to call on staff to, as you decide among yourselves, to present the request.
Okay. The new zoning code requires that drive-throughs be approved by conditional use in our commercial districts. And the rationale behind that, as you recall, when we went through the zoning code update, was to make sure that drive-through locations weren't having adverse effects on neighboring properties. Most notable is commercial properties that might be adjacent to residential properties. Commercial property with a drive-through, obviously you'll have traffic. If you're next to something that's next to a property that's less intensive, you might want to be able to impose some conditions to mitigate any of those impact concerns. So this property right now is in the process of being annexed into the community. This is the site of the liquor store and motel, and then there is some vacant lands to the west of that. The city will be extending Elm Street to the north up to County V. There will be a remnant piece of land that the petitioner is proposing to buy in conjunction with the liquor store and motel. The findings that Ms. Lazares talked about are the things that we're primarily concerned about here. First and foremost is the proposed conditional use in harmony with the purposes and goals of the comprehensive plan. Your comprehensive plan promotes infill development and redevelopment of properties where possible. This proposed use and development does exactly that. The long-range plan calls for the area to be planned business. It is zoned planned business, or R1, but it's intended to be zoned planned business when it annexes. It has had 2 readings at the council to date, so it should be annexed beginning of next month at the next council meeting. December 1st, so next week. So that's why the condition was added to complete the annexation. Drive-through facilities are standard for restaurants along certain roadways, specifically county roads at the intersection of 89. This is obviously an area for indoor commercial activities. So the request is certainly in keeping with what the community has planned for a number of years out in this area. Does the proposed conditional use result in adverse effects on neighboring properties? In the staff's opinion, it does not. In fact, it is in compliance with what has been planned for that area, whether it's in the TIF project plans, the redevelopment plan, or the comprehensive plan. It is for improved commercial use out at the intersection. The planned business district does, as they go through the process, does impose some requirements on building design and site design that they would have to comply with, but that's really kind of separate from the request to have the drive-through. Does the conditional use maintain the desired consistency of land uses out there? Again, as I said, yes. It is intended for commercial. There are automotive-related uses out there already. This is a continuation of that. It is not surrounded by residential, so you don't have conflicting land uses in the area. It is surrounded by uses that are auto-oriented. Will it be adequately served by public utilities and infrastructure? Again, the answer is yes. It's on a county road. It's at the intersection of a state road. Obviously, it's along near the interstate. It will have public sewer and water. It will have stormwater management facilities available to it. It will have good access to both New Elm Street and to County V. And then do the potential benefits of the proposed conditional use outweigh any adverse impacts? And staff's opinion that the benefits do outweigh any of the potential adverse impacts. Again, you have redevelopment of property through the standard process of property owners working with another to buy and sell property and redevelop it. It takes a remnant piece of land and packages it to an existing piece of land to make the site a little more saleable. It has good access, so the staff is supportive of this. Again, the focus tonight is just on a conditional use for the proposed property to have a drive-through.
Vicki, do you have anything you want to say?
I don't have anything at this time. I think the planner pretty much covered it.
All right, very well.
I do have a couple things I'd like to comment on. In 2003, the council had a strategic plan which incorporated the redevelopment and development of a TID or properties in this area, and they moved forward with a TID project which created TID number 4, the first one. It incorporated all these areas and looked at the issues that were ongoing. We did a 2005 transportation study. We did a 2005 North Side Neighborhood Plan. We did a 2006 TID amendment. Then we did the comprehensive plan.
Yeah.
And all of those plans, including TID amendment number 2 and now TID amendment number 3, all directed city staff to move economic development in these locations forward. And we did a 2013 traffic impact analysis. We went through and looked at all the traffic issues from from east of Cherokee Path to west of the Lake Mills Market, and made analysis, and that came out into recommendations, which you see in the TID map, which has Elm Street on it and shows alternate drives in and out. The Strong Towns report also was important in making these determinations, because they said that they wanted to see more alternate streets to keep from having to make Main Street 4 lanes or more. And so all the things that we've done as far as planning in this area has met all the goals that the staff has been directed to do through multiple documents and years and different councils. So we feel that we have provided what the council has wanted as far as economic development and how it should be done. So this is a continuance of that.
Okay. All right, very well. That's a good background, and what City Manager Wilkie is saying is there certainly has been a deliberate planning effort in that area for the past 12 years and beyond. So this is we're seeing a situation that fits into what has been planned for a long time. The public hearing is open. Does anyone wish to speak to this conditional use request? Yes, and please approach the podium and then sign your name, and then also say your name for the record too.
Martin Lira. I'm a 28-year resident of the Lake Mills area, N6565 Shorewood Hills Road. I am the co-owner of the property at W7655 Highway V, also the business owner of TLC Car Wash, and the landlord of the pizza pit on that property. A couple things I'd just like to bring to everyone's attention. We've been at that facility operating a car wash and a pizza pit for almost 19 years. Since the inception of the car wash and the pizza pit, we have had an agreement with all the previous owners of the liquor store to mutually use each other's property for the need of both the liquor store and the car wash. Meaning cars from my facility and cars from the business next to me do cross the lot line in the use of the business. For me, it's a necessity to get cars into the car washing bays. We think, myself and my business partner think Culver's would be a great addition to this town. There's no doubt about that. It's something that we think could help the community. It could help my business. As long as having that business there doesn't adversely affect my business. And I have to be able to get cars into my car wash. Some of the site plans that I have seen may limit that, and that's where my true concern lies. My attorney and John's attorney are starting to communicate and work on some type of an agreement or easement to continue to allow cars into my facility. That's really the premise of what I wanted to speak to publicly here, is to let you know there is, in my opinion, an adverse condition, not knowing what the final site plan is of the property yet, or the lay of the land. So with that said, I just feel that the situation needs an additional time to work out a solution before any approvals can be made. Because I need to know that my facility is going to stay in business and operate as it has for the last 19 years.
Okay, all right. All right, thank you, Mr. Lira.
Yep, thank you.
Does anyone wish to speak at this time? Yes, sir. You go ahead and approach the podium, and then say your name for the record and also sign.
My name is Ted Meredith,
Meredith, yes, yes.
320 East Stewart Drive, Oak Creek, Wisconsin. John had asked me to speak to this commission, and I'd like to thank you for that opportunity. The concern that Mr. Lira addressed is a legal matter. I understand that the adjacent property was using part of the property that is for sale. But the conditions for adverse possession they're legal. And there is no legal precedent for that adversity to exist. It's simply a property line. The property that is being developed by Mr. Laundrie is still in the preliminary phases. Mr. Lira has no legal basis for his contention, and I understand that he can potentially be hurt by that if the property is fully developed. Mr. Laundrie is sympathetic to that, and we are willing to look at that, but it cannot be a condition of sale. If there is an ability to accommodate the adjacent property, we have no desire to hurt another business. We will make every reasonable accommodation that doesn't hurt this development. We are open to any questions or any comments from the commission, and again, I'd like to thank you for the time.
Okay, all right, thank you, Mr. Meredith. Does anyone wish to speak under this public hearing?
Could I make an additional comment?
Yes, yes.
City staff has discussed with both property owners that we would be willing to work on certain conditions if they're willing to come to an agreement. That might be outside the standard for what we'd see in a normal property. So we'd have to be willing to be a little bit flexible and look at some things that, where we would do cross-access easements that might affect the green spaces on the site.
Okay, all right, thank you, Mr. Wilkie. The public hearing is still open. Is there anyone else who wishes to address the commission under this public hearing item? All right, hearing none, then we close the public hearing and we go to item number 6, discussion recommendation. Conditional use request, John Laundry, Restaurant Drive-Through, West 7659, County Road V, parcel 018-0713-1223003, under the condition this property first be annexed into the city of Lake Mills. We are now in discussion in the Plan Commissioners. If you have questions of the applicants and their representatives of anyone who has spoken of staff, then this would be the time to do that. I guess one question I have is that as you are willing to consider the concerns of the neighboring business, will this would this change the how the drive-through is set on the property? Would this change the position of the drive-through?
We don't know.
Okay.
I think that's the short, we're in a very preliminary design. If you look at the site plan, that is part of the package we
Yeah.
have. Right now, there isn't enough space dimensionally to accommodate our standards for a drive-through. If you look at the south end of the building, the access to the drive-through is limited to one lane. The standard is two, so that if somebody decides that they want to go
Alright.
inside or bypass the drive-through for whatever reason, they can pull out of the lane. You can hire a placing in order to circulate back onto the site. Additionally, that building is located there because it is the furthest away from any access points onto the property and minimizes any chances of cars stacking and potentially blocking access, which could create a dangerous condition outside. So, we don't know. We're still in the preliminary design phase. That's the best I've got for you right now.
Yeah, you have to remember, this isn't a site plan review. This is just to
Right,
determine
yeah.
whether the
The conditional
drive-through is an
use.
appropriate use in that location. And that's why when I talk about it, I look at the area here and how we've constructed the streets and the alternate accesses for all the local businesses and how we're trying to construct traffic in the area. Because a drive-through obviously is a business that would affect traffic. The overall site plan would have to be submitted with all the information, and staff would review that and finalize it. So the exact location of the driveways, those types of things. If there is some type of change in how the site would be from normal, now let's say Culver's came in and they just submitted a normal site plan, staff would review it, approve it, and it would be constructed. Once you start moving out of that normal, so there could be like 3 or 4 items that we would discuss, in a lane along the west side of the car wash, starting at at their parking lot by the Pizza Pit and running along the west side. In transition, the car wash might provide some parking on the back side of their property for Culver's. So we would have to figure out how to make that all work, and then we might have to come back. Well, I'm positive if we had some modification of the green space on the site, we'd have to come back and have the council review it and make a decision. So that's kind of where we're working at.
Yeah, because we can't really actually say whether it'd be adversely affecting anyone at this point right now, because we don't have a site plan to work off of. What
Okay.
Mr. Meredith is working off of is the need to get this conditional use either approved or denied so they can move forward with the planning to get to a point where we get a site plan on it. And unless I'm wrong, that's really what we're trying to do here, is see if, is this a good use for this, not whether or not it encroaches on the neighboring issue yet. It's just
Right,
whether or
well-
not that's a good use for that, to have a drive-through there, so.
And you have to remember that we have to weigh and balance certain issues.
Yep.
What Mr. Lyra's legal right is to be able to use that property is in question and is not an issue for the Plan Commission or the city at all. Our issue is this an appropriate spot for a drive-through use? And everything that we've done to date would make this an appropriate site for that. Whatever business bought this site, I'm assuming that they have the property rights to use it in the fashion that they deem most appropriate for their business. To be able to work out issues on that with Mr. Lyra is between the two property owners. It's not a decision for the city. So for us to weigh that as a adverse impact is difficult. We would have to look at traffic issues, drive-through issues, parking issues, those types of things. That's not for us to weigh. Now, for us to be as helpful as possible in solving both problems, that's our job. And we will do everything we can to help work through those issues. But there are 3 sites that are actually 4 sites that are potentially impacted here by this issue. I mean, that building is in a very tight piece of property. And so, you know, it limits us, and because, as I understand, the BP sees what they've authorized as use to be just an out, not to allow cars to stack. As far as I understand, there's no actual easement to allow cars to use or stack on the hotel property. So this is more of a, what can 2 neighbors work out that's beneficial to both of them, and how do they handle that? And then can the city work with them to make it work? And we will work through that as part of the site plan review and what they discuss. But in the long run, I assume that from your standpoint, it's whether this is an appropriate site for a drive-through or not.
Plan
I guess that's how I'd see it, as a drive-through issue. The difference between the 2 property owners, they're going to have to work that one out.
Yes. Plan commissioners, are you comfortable with the plan commission motion, and realizing that certainly there may be some shifts in the final plan, but really what we're considering is a conditional use for the drive-through at this location for a permitted use. So I guess that'd be my question. Are you comfortable with the plan commission motion and allow it to go forward? Because certainly any changes to what we're seeing here would be staff reviewed and undergo the rigors of the zoning ordinance. So,
I would be.
Yeah, I do.
all right. Is there a motion concerning motion 1511-1?
I would move for passage of motion 15-11-1 for a conditional use permit for a drive-through.
I'll second it.
Okay, it's been moved and seconded. Is there further discussion?
I have no problem with what's being proposed. I'm sure that the gentlemen can get their differences worked out. I have just one problem, and I'm sure you're going to shoot me down on this, staff, but the boulevard tells me that we're only going to make right turns coming out of that restaurant. Nobody will be able to make a left turn into it, and nobody can make a left turn into Quick Trip after going east on Tyranina Road. That's basically what I'm looking at?
Yes, you are. And let me drill down further into that. We did the traffic impact analysis, and if you remember, we had Elm Street coming out tight, actually right over the top of the liquor store, and running right up alongside the edge of Quick Trip. A lot of advantages to that from two positions. One of them we were looking at how we could stack cars in there right away to get into the car wash, and how to get cars out of Quick Trip without having to develop a special driveway. When we did the traffic impact analysis, the state told us that based on the queuing that they expected and how they were going to set up the traffic signal, they were going to put in a 267-foot island. Okay, that 267-foot island is where Elm Street starts.
Yep.
There's a trigger on that for when the DOT would determine that it would be appropriate to put that island in. It also allows the city to make that decision earlier if there start to be significant traffic impacts. That being said, we've taken the position that we want to hold off on it as long as possible, while we have provided as many alternate accesses, and that we hope that those work in the long run. The initial approach is to leave it this way as long as possible. Ultimately, the traffic will be so bad there, and you look at it right here now, and I'll pull this up as good as I can. Traffic making this corner here and then pulling into this driveway. If it's a semi-truck, that semi-truck can sit here in this lane and block all traffic in that intersection for as long as it wants until it can get into this driveway. And a lot of times there's a car sitting right here that blocks that and can't get into this lane because there's traffic queued up back far enough that the car can't get out. That blocks up the whole intersection. That isn't an issue that's going to affect these properties over here. That's an issue that's ongoing over here. So how does the city take care of that issue?
How
Well-
do we take care of that?
Yeah.
What about a third lane? Widen that street so we have a center lane for left turns.
Well, an additional lane would be appropriate, but now you have semi-trucks that have to come out, and the traffic is backed up to this point back here. So all these semi-trucks are stacking here. Then what do you do?
I don't know. I'm just saying, I'm bringing this up because there'd be
Alright.
no left turns going on. No one's gonna come off the
Right.
freeway and make a right turn onto V and then turn left into Culvers because they can't get there.
Right.
And you
So-
can't get to the BP unless they go cross the intersection and come BP around the back.
Right. So what we've done here, Ken, is for Quick Trip, what we in the long term plan to do is run that this is the only driveway that they have, and we make it a normal sized driveway, because what happens is you get 5-6 cars stacked up in these driveways and they're all pulling out into traffic. That creates more traffic conflicts than the normal driveway, which meters it out one at a time. So at the most 2 at a time. What we want to do is make this an in and then this an out.
Oh, okay.
So it comes up here and comes down and then comes through the intersection. So then you don't have to worry about getting across that island. On the other side here you have BP. What we'd like to do is have them improve their signage to say that trucks should come in here. We'll have to move that fire hydrant because it's already a hazard. But we get them in this lane here, they pull into here, they actually pull into the here, and then they can pull back out onto this road without any problem. Right now what they're doing is they're coming in, turning in here, then they come down here, back up into here, and come back out this way. Because they have a very difficult time making this corner with this extension right here. So actually, the traffic flow here would be better. But let's say for some reason they came in and they got in here like this. There's an alternate out right here. You see that driveway coming out?
Yep, I see that.
Subway and BP have a cross-access easement, and so people in Subway and BP could come out this driveway right here. So we've tried to make as much alternate traffic options as possible, knowing that at some point in the future, the queuing at that intersection there would be so many cars, the traffic island would be irrelevant. The traffic island just tries to prevent idiots from trying to bust their way into a short lane of traffic. But technically, the traffic is going to do it. So we've been spending all our time working with the owners, and we have contacted both BP and Quick Trip and discussed with them, and they know the issues here. We also have provided another driveway right here, and I assume that this is vacant land that probably will end up being commercial and we'll have driveways. But that being said, we've planned into this as much as we can. This is another thing we've done is this is real narrow down here. This is real wide up here. So it encourages the semi trucks not to head south, but to head north and back out to V.
Steve, if I can add, I feel compelled when you're looking at the existing development versus new development.
I know this is preliminary, but
Yep.
I saw that, and I just thought, whoa, we're gonna have people getting upset about not being able to turn.
You can see the difference between doing development in the town, which was Quick Trip, the motel, the car wash, et cetera, and development that happens in the city. There's a reason the city has certain codes, requirements for queuing of traffic, throat length at access points, everything from landscape islands. Quick Trip found that out when their sign got knocked down. We require lights and landscape and signage be placed inside landscape islands protected by curbs. There's reasons for this, and it gets back to making sure that circulation on site works properly, and then the egress back out onto public roads is appropriate, so we can minimize as many conflict points as is practical. And so tonight is about the whether or not the property in question is suitable for a drive-through facility. The next step is working through the code with the property owners on their development to make sure that I's are dotted and T's are crossed, that we aren't creating problems, traffic noise or otherwise, elsewhere. So.
But Ken, to answer your question, we've done as much. This won't occur immediately.
I didn't mean to throw a wrench in the gears here. I just
No.
noticed that. I've lived in an area at one time that had that type of a situation. That's why I was just
Yeah.
bringing it up.
We were kind of, I guess, when the traffic impact analysis came through, at least from my standpoint, I was kind of surprised. I don't know if the traffic analysts were, but it wasn't in the original transportation plan. That being said, since we've had the traffic impact analysis done, we've done everything we can to mitigate the problems as much as we can. Now, if you read the engineer's report about the traffic,
I went through it, yep.
we are going to allow them to have an in and out driveway on V with the knowledge that we can take it away at a certain point. But they felt that in order to get their business up and established, it would be better to have an easy access rather than a hard. And once they become, people know about them and they've been there and had an experience, that they will understand how to get in from the other direction. There will always be an out there, but there probably won't always be an in. And we've made sure that they knew that. We had to go have some conversations with the county about how we were going to handle this. They're comfortable with it. Our engineer is comfortable with it, but the business has to know that in the long run, they will not have full access out of that drive. And in fact, we already had some discussions on how you do the left turn lane at Elm Street and the left turn into their driveway. Because we'll have to widen that street, we'll have to widen V to have an east to west and a right left.
I see in the sketch you got an ingress, egress on Elm Street, on the plain paper one here.
Yep.
Okay, I'm satisfied, thank you.
Planning Commissioners, we do have a motion and a second to pass the Plan Commission motion 1511-1. Is there further discussion? Hearing none, then I'll call for a roll call vote.
Mr. Magnuson?
Aye.
Mr. Schwark?
Aye.
Mr. Pearson?
Aye.
Mr. Foster?
Aye.
Ms. Lazaris?
Aye.
Motion passed 5-0.
The next item is item number 7, public hearing amendment number 3 to the territory and project plan for tax increment financing District Number 4 in the city. And here we have before us Resolution 15-1, resolution amending the boundary and approving the tax incremental District Number 4 project plan for City of Lake Mills, Wisconsin. Now, Resolution 15-1 sets forth a tax increment financing authority under Wisconsin state statutes. The city's determination to use tax increment financing to promote development and redevelopment. The background of tax increment financing District Number 4, created in 2006, and its earlier amendments of 2007 and 2013. The amendment now proposed to tax increment financing District Number 4 and its project plan to include A, list of the kind, number, and location of all proposed public works or improvements within the district, or to the extent provided in state statutes outside the district. B, an economic feasibility study. C, list of estimated project costs. D, description of estimated cost financing and the time frame in which these costs will be incurred. E, a map showing existing uses and conditions of real property in the district. F, a map showing proposed improvements and uses in the district. G, proposed changes in zoning ordinances, master plan, map, building codes, and city ordinances. H, a list of estimated non-project costs. I, statement regarding any relocation. J, statement on how the amendment promotes orderly development. K, city attorney opinion on plan compliance with state law. It also sets forth that the project costs may include cash grants made by the city to owners, lessees, or developers of land within the tax incremental district and projects within the proposed boundary and within a 1/2 mile radius of the proposed boundary of the district. This resolution also sets forth the notices provided to local taxing jurisdictions and sets forth tonight's public hearing. Plan Commission Resolution 15-1 first approves the tax increment financing District Number 4 boundary amendment. Second, it states that at least 50% of the district is suited to mixed-use development. 3, declares the district a mixed-use district with residential development not to be part of the project plan. 4, finds that equalized value of all TIF districts in the city will not exceed 12% of the total equalized value of taxable property in the city. 5, states that any property which is vacant and more than 25% of the district area is suited to mixed-use development, and the project plan would promote these uses. 6, approves the tax increment financing Number 4 amendment Number 3 and recommends approval to the City Council. 7, confirms that territory annexed into the city is subject to revenue sharing according to the city-town intergovernmental agreement. And 8, declares the amended district project plan feasible and that it promotes orderly development conforming with the comprehensive plan. So that's the resolution that we have before us, and I would just ask for staff to provide an overview of the of this amendment.
Okay, thank you. The resolution is very long because the state, Department of Revenue, is very specific in what it wants to see in that resolution. And they kind of check the boxes to make sure all those specific statements are properly made. As Ms. Lazara said, this is a territory amendment to add territory. It is the third amendment for TID 4, which is generally that area at 89 and County V. The last territory amendment included the Gunlock property, which is the Lake Mills Market. This amendment is to include the lands that we talked about on the earlier agenda item, the area around the Elm Street extension, including the Simden remnant piece and the motel site, and then also to include the Linda Keith property, which is located a little further to the west, which is directly south. It's generally the farm field south of the Lake Mills Market. The project plan is updating or reiterating elements from the previous amendments. In essence, and what this amendment is for, to add territory, discussing the existing conditions of property, why are we undertaking this, will this amendment further the orderly development of the community and such. As Steve had outlined earlier, this area has been planned at many levels for the better part of a decade and a half, for encouraging economic development activity out on at this intersection. Obviously, it's an important gateway to the community, and the plan, the project plan and the TIF in and of itself is to help encourage that development. But for the assistance of the community on leveling the playing field in some cases, improving access or infrastructure, some of this development wouldn't happen. In this case, helping package properties together, extension of roadways, payment for some of those infrastructure improvements, such things as improving electrical connectivity, et cetera. So that's what this plan really runs through. Jim Mann from Ehlers is here to talk about the financials as necessary, but in essence, we are really only adding 3 properties to the district itself, and then really dotting I's and crossing T's with the statutory requirements for the project plan amendment. This is, as we said, the third. You're allowed 4 project plan or territory amendments over the life of the district. So there would be the opportunity in the future for one more territory amendment under this TID, under TID 4. There is still some vacant lands that have not ripened yet for development. Those are the areas kind of north of Quick Trip and to the north of McDonald's. Those vacant lands there, but in essence to encourage or spur the redevelopment of a couple of these sites that we've talked about that have been highlighted for this project plan. The amendment really is necessary to assist development. Jim wants to.
Thank you. So really, it comes down to the nuts and bolts of the finances for when you're looking at a tax increment district. One of the items that you're charged with is making sure that the economic feasibility actually is in a positive situation as opposed to a negative situation. In this case, we're looking at not adding any real additionally new project costs. These are all project costs that were included in the original amendment number 2 for tax increment district number 4 that basically opened up a lot of the area for development. However, we're adding the territory because these properties definitely benefit from the infrastructure that's going to be put in the ground, and they should share in some of the costs associated with putting that infrastructure in the ground. So therefore, by bringing the territory in, you're capturing the increment, and in this case, we're looking at about $4 million worth of increment that's going to be generated between the Culver's development and then a guess at what may happen on the parcel that's directly across from the Lake Mills Market. That's going to put the tax increment district in a more positive position than it currently is. When we look at the overall cash flow of the district in terms of what the increment being generated is right now, if no amendment is made and only the Lake Mills Market development moves forward, the tax increment district is going to use the remaining life, its maximum life, to pay off its obligations. The addition of this territory actually moves that bar 1 year closer based upon the development that we know about. So it moves you that much closer to being able to close the tax increment district and put it back on the tax roll for the benefit of the broader city as opposed just for the tax increment district. Now there's a number of other areas within the tax increment district that could develop, but we don't have any concrete plans. As Dustin said, nothing's ripened at this point. So we're only really looking at what we can count on right now in terms of development, and that's going to, with this amendment, move the bar for closure 1 year closer. So it's a positive all the way around for the tax increment district.
There are a couple items that probably should be brought up in that. You probably remember where we had the town of Lake Mills give us the Elm Street right away back in 2004. So they sent over a document requesting that we annex the Elm Street right away, which had existed. It dead ended at the back of the motel liquor store, and we took care of that. Elm Street was scheduled to be constructed and actually was a part of the design plans for the Birch Street, which was completed 2 years ago. We had to pull it out because the Walgreens tax assessment was lowered by $1 million, and Act 10 lowered levies from 24 to 22, which impacted the amount of increment we received. So we didn't have enough annual revenue to cover the debt that would have taken to build both streets. We also added $1 million of electric and about $750 worth of sewer and those types of things. But the total debt we tried to reduce by not building Elm Street. Actually, the vision at the time was that Elm Street was actually part of the TID Amendment number 2 and didn't include this property being in the city. It was actually in the town.
Right.
But the TID allows you to build right-of-ways that aren't necessarily within they have to be within a certain distance of the TID, but they don't have to be in it. This allows us to put almost all of Elm Street in the TID. So the Anytime Fitness building that got constructed at the Lake Mills project added another $1 million, which made up for the Walgreens assessment we lost. So we're back to zero. And Culver's will add for the mill rate reduction that we took, which will now give us enough revenue to pay for Elm Street. So that's how this all falls together.
Right.
No borrowing?
We'll have to borrow, but the increment that Culver's generates will pay for the borrowing.
Easily.
Yeah.
It's consistent with everything that we've done in the TID. Jim will be happy.
But as TIDS goes, this is a highly successful one, really.
All our TIDs have been highly successful. We haven't had a bad one yet. This one got to the point where we were starting to sweat a little bit when Walgreens was fighting their assessment.
Okay.
And I don't know if you've been following the dark store legislation going on before the Wisconsin legislature right now, but the courts and the Department of Administration have been in kind of a battle on how to assess certain properties. And what they have is you have a company like Walgreens or Menards or Target, and they set up this holding company that buys the building, and then they lease it from it. And then they claim that this lease doesn't have the same value as the property, and so now you're in a court, and the court is saying, well, yeah, we agree with, and DOA is saying, well, this is how you have to assess it, and so we have to assess it in this fashion. They approve it, and then the court changes it. So it's made for a lot of strange activity within the state, and finally it got big enough that the legislature's decided to handle it. I'm hoping that they fine for cities rather than.
Yeah, well, we took our hit on Walgreens. We're not going to take another one.
Oh, well, we could take a lot of hits if the legislature doesn't fix this hole. So I'm hoping that they fine for cities for a change. But from my standpoint, as far as this TID goes, we've been doing well, and we'll continue to do well based on these projects.
Yeah, and your project plans are just the 2 streets, the additional future streets across the road.
Yes, we'll
So
extend
those
one
aren't huge either.
Right, and while we're getting kind of short on the TID, because you can only do projects up until, what, 2021?
5 years before it expires.
Yeah, so that takes us to 2022, and then you have another 5 years where you can collect increment. That being said, most of those projects of that type would require longer debt periods. So we might have to come back and lay a TID over the top of this one somehow, like we did in TID number 2 and TID number 6.
It all depends on the
Yes,
property owner too.
yes. You
Well,
might have to.
yes.
May I?
Yes.
There is a piece of legislation in front of the legislature right now that would create an adverse impact clause in the TID statute that basically, if you recall, a couple years ago when the state funded the vocational technical colleges, Act 145, at a much higher rate, that dropped everyone's mill rate by approximately 90 cents. That, under this piece of legislation, would be considered an adverse impact that was outside of the city's control. And that would allow you to extend the life of the tax increment district 5 years. So that may give you, if we get down to it, some additional breathing room in terms of the operation of this TID without having to necessarily go the route of having to do an overlay district or closing this district and creating a new one.
A political solution.
Yes, Ken, we have to watch everything the legislature does because they giveth and they taketh away.
Yes, they do.
So if you have the opportunity to talk to your legislators, suggest that they approve these TIF bills that are sitting before their particular houses.
Okay, we're still in public hearing. Staff, did you have any more to review for this amendment?
I do not.
Okay. All right, we're still in public hearing. Does anyone wish to speak to the public hearing on amending tax increment financing district number 4? No one is coming forward, therefore we close the public hearing and we go to item number 8, discussion recommendation, amendment number 3 to the territory and project plan for tax increment financing district number 4 in the city of Lake Mills. Okay. Are there any questions of staff plan commission for this resolution before us?
Just to comment, it's all part of our long-range planning.
Yes.
Culmination.
Yes, it is. Yes, it
I
is.
think it's excellent planning that's taking place in our community.
And it all ties together. Okay. Does anyone wish to make a motion regarding Resolution 15-1?
I would move for passage of Resolution 15-1, a resolution amending the boundary and approving the tax incremental district number 4 project plan for the city of Lake Mills.
Is there a second?
Second.
Okay. It's been moved and seconded to approve Resolution 15-1. Is there any discussion? Okay, hearing none, then I'll call for a roll call vote.
Mr. Shork?
Aye.
Mr. Pearson?
Aye.
Mr. Foster?
Aye.
Ms. Lazaris?
Aye.
Mr. Magnuson?
Aye.
Motion passed 5-0.
All right, the next item is recommendation, item number 9, recommendation for future agendas. Is there anything that is coming forward? Now, Misty, you had mentioned, about the,
Possibility of a work session.
Yes.
There's going to, the council has gone paperless and uses iPads for their packets, and we're now at the phase of going to the plan commission with the iPads as well. So a distribution and review of how to utilize those.
and will there be some more information coming as to when we'll have our work session for that?
Yes, I'll look at the meeting for next month, and then myself or Heather will call to check on availability.
All right, well, that
I
sounds.
had a question about a future meeting in December.
Yeah, see, we're under the future agendas and.
Well,
So-
we had some dates. They were,
Yeah, I don't know if the date's gonna work for next month.
Oh, yes, so there was the memo on the dates for next month, that the Tuesday, the fourth Tuesday falls on the 22nd, and so if there's a conflict, then there is a fifth Tuesday in December, the 29th. And so what is everyone's schedule for the 22nd?
I would prefer the 22nd myself.
How about the rest of you? Are you fine with the 22nd?
I'm on vacation, I might as well come down that night.
Okay.
Yep, whatever.
Whatever's
Just
fair.
hanging out.
All right. It looks like the 22nd would be fine. What about staff? How about the staff?
22nd?
Yes.
22nd is a lot better for me.
Okay.
We're just doing the zoning.
Well, it's always on the calendar.
She's just looking at it.
He vacated the position. Yeah, he did.
I'll check with her, but it's always on the
Yeah.
calendar for me, so.
Now we have an opening.
It's an opening, yeah. Oh, is that? Okay. All right.
It's on the way home.
So staff, were you fine with the 22nd?
Yes, I am.
Okay, what about you?
29th would not work for me.
How about you, Dustin? Are you fine?
Second is very good. 29th
Okay.
is out of town for holidays.
Okay, all right, very good. Okay, so the 22nd is going to work out. Is there anything else that, that we should be talking about under the future agendas at this time? Okay, all right, well, if not, then wishing everyone a happy Thanksgiving, and we are on to then item number 10 for adjournment.
So moved.
Second.
Moved and seconded. Any argument? In that case, we are adjourned.